Testing, testing. All right, good morning. Welcome to the 294th District Court. My name is Chris Martin. I'm going to call this morning's criminal docket. When you hear your name, please say present or here. Christopher Blevins. Here. David Brooks. Here. Nathaniel Brooks. Nathaniel Jr. Brooks. Max Juarez. Max Alexander Juarez. Mark Martinez. Here. Chrissy Kaiser. Miss Harrington, counsel for Miss Kaiser, had filed a motion for continuance. The court's granting that. However, we've informed her, or we are informing her. Okay. Court's granted that motion for continuance, and the court is setting this case for September 16th for docket call.
Yes.
Wyatt Berkwin. Wyatt Lane Berkwin. Okay. We'll recall that case. Shunta Foster. She's been verified in Gregg County, CR 24164. We will recall that case. Jeremiah Holmes. Here. Isaac Jenkins. Tanya Mons. Is it Tanya or Tana? I can't remember. Tanya. Is it spelled Tayna? Tanya. So the Y is before the N, and it's Tanya.
It's pronounced different.
Okay. Just going to apologize because I'm going to struggle with that probably from here on out. But I've got you checked in. Damian Wiles. Charles Bell. Philip Swallows. He is here. All right. Is there anyone in the courtroom your name's not been called? You expect to be on the morning docket? Your name's Mr. Juarez. I've got you. You were late, but I've got you written down. Who else? Anyone else? All right, do we have any counsel that's ready? That's not a plea. That's not a plea. Just because it's going to take a moment to set those up. Sorry, Mr. Weld. Mr. Schmidt, who are you ready on?
Jeremiah Holmes.
Mr. Holmes. This is cause number CR 24-141, State versus Jeremiah Garen Holmes for docket call. Go ahead, Mr. Schmidt.
Judge, we're going to ask for additional docket call setting for Mr. Holmes.
I'm sorry, I couldn't hear you.
I said I'm going to ask for an additional docket call setting.
You trying to get good, but for today, what we're gonna do is try to get you reset. Just let okay. Yes.
It's okay. It's okay.
What's the purpose for the additional time?
I need more time to talk to Mr. Holmes.
Any objection from the state?
Your Honor, no objection. I'm just checking on one thing. I want to make sure we have signed conditions of pretrial release with no contact orders. So I'm just checking to make sure we have that.
All right, September 16th.
Yes, sir.
All right, that'll be a final docket call for Mr. Holmes.
Now, if you're gonna get another one, but also because this will be the last chance you get.
Do you need Mr. Holmes to stay to check in with pretrial release? Is that what you're saying?
Yes, Your Honor.
If you haven't, just
When you think
say again.
do you think we could come to
Probably.
What if should you also check with Hartwell to what the issue is?
And
Here, just tell me.
Does he need to check in, Judge?
Hold on, I'm about to be told of it. So, Scott. Yes, sir, just, I'll tell you what, have a seat right there. And then they'll be with you in just a moment. Who's next, Mr. Schmidt?
Isaac Jenkins.
Mr. Jenkins,
I don't have his.
this is cause number CR 25-126, State versus Isaac Anthony Jenkins. All right, Mr. Jenkins, is set for pretrial.
We have no contested pretrial, Judge. This time ask for a docket call setting.
All right, court will set Mr. Jenkins for pretrial September 30th.
September 30th, Judge?
30th. That'll be at 9 a.m. No, I'm sorry, docket call. He said we're on pretrial.
Is he free to leave, Judge?
Yes, we did.
We'll talk.
Who's next?
Tana Mons.
Bonds. This is cause numbers CR 25-99, 2025-62, 2025-209. Appears that we're set for pretrial on the injury to a child, purchasing, furnishing alcohol to a minor, and then docket call on the assault that was transferred up, I believe. Go ahead.
That's right. And Judge, we're still working with the state, but we have no contested pretrial. We'd ask that all of those cases be carried on a docket call.
All right, there being no contested pretrials, court sets Ms. Mons for docket call on all cases September 30th.
They haven't yet. He said it's
At 9 a.m. Who's next, Mr. Schmidt?
Damian Wilaz.
Mr. Wallace. CR 25-174, State versus Damian Alexander Wallace. And we are set for arraignment.
And Judge, we understand what we're charged with. His name is spelled correctly. We'll wait formal reading of that indictment, enter a plea of not guilty, ask for a pretrial setting.
Court enters the defendant's plea of not guilty into the record and sets the defendant for pretrial hearing is September 30th. Sufficient, Mr. Schmidt.
Yes, sir.
September 30th at 9 a.m. Mr. Schmidt, if you'll inquire with Mr. Wallace if he signed his conditions of pretrial release.
Yes, sir. He and I are going to meet in the hallway. I'll check with Mr. West before he leaves here.
Thank you, sir. Why are you ready on Mr. Swallows?
Yes, Ryan.
Mr. Wells, I don't see a plea.
Just look at the papers with your new electronic method. Patty told me she had them back, so I don't know.
Yeah, I'm looking at my email right now. I don't see them. So
Well, I'll go ask her.
yeah, ask her to double check. I don't see that they've been forwarded to me. All right, Mr. Swallows, this is cause number CR 25-16, State of Texas versus Philip Wayne Swallows. Mr. Swallows, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. You can lower your hand. All right, Mr. Swallows, are you a United States citizen who reads, writes, and speaks English?
Yes.
Have you ever been diagnosed with a mental condition?
No.
In this case, you're represented by your attorney, Mr. Nolan White. Are you pleased with Mr. White and the work that he's done as your attorney?
Yes.
Do you understand everything that you've read and signed today that's part of your plea agreement?
Yes, I do.
Do you have any questions about any of the paperwork or proceeding before we go further?
No, sir.
Mr. White, do you believe Mr. Swallows to be competent to enter into the plea agreement? And if so, do you believe he's entering into it intentionally, knowingly, voluntarily after you've explained to him his rights?
I do, Your Honor.
All right, Mr. Swallows, I see that you were originally indicted with a second-degree felony offense of burglary of a habitation. However, it appears today that there is a plea agreement in your case, and the state is recommending that upon your plea of guilty, that the court convict you of a lesser included offense of Class A misdemeanor criminal trespass of a habitation. The plea recommendation is for punishment to be assessed at 2 days confinement in the county jail, with you receiving credit for 2 days of time already served, a $2,500 fine plus $270 in court cost and $35 in reimbursement fees. Mr. Swallows, is that your understanding of the plea agreement?
I didn't know about the $270 for court costs, but the rest I understand.
Okay. Do you need to talk to Mr. White about that?
I can do that afterwards. He can instruct me where to pay that. It's all important.
All right, the range of punishment for a Class A misdemeanor is confinement not more than 365 days or a fine not to exceed more than $4,000 or both. Understanding the range of punishment, understanding the plea agreement, Mr. Swallows, how do you plead to Class A misdemeanor criminal trespass of a habitation?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime? Now you're shaking your head no. If you shake your head no, that tells me that you are not making a judicial.
Yes, sir.
Hang on. It means you're not making a judicial admission of guilt. And so if you do not believe that you're guilty, or you're telling me that you in fact are not guilty, then this court cannot allow you to plead guilty to an offense that you're not guilty of committing. So I'm going to recall your case in a few minutes, have a seat and have a discussion with Mr. White, and I'll call you back up when you are ready. Okay? Mr. Wells, you ready?
I am, Judge.
Mr. Bell? This is cause number CR 24-298, CR 25-1, State of Texas versus Charles Kenneth Bell. Mr. Bell, since you're entering a plea today, I'm going to have you raise your right hand so I can place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, Your Honor.
Thank you, sir. You can lower your hand. All right. Is your name Charles Kenneth Bell?
Yes, sir.
And Mr. Bell, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Ron Wells. Are you pleased with Mr. Wells and the work that he's done as your attorney?
I'm sorry.
It's okay. I said, are you pleased with Mr. Wells and the work that he has done as your attorney?
Yes, sir.
Do you have any questions about any of the paperwork that you've signed today that contains your plea agreement?
No, sir.
Do you have any questions about anything before we go further?
Judge, she just has a question about a pretrial fee, and I'll talk to Todd about that.
It's not an issue that.
Not an issue on the plea.
Okay.
Sorry.
Anything else, Mr. Bell?
No, sir.
All right. Mr. Wells, do you believe Mr. Bell to be competent? And if so, have you explained to him his rights regarding these cases, including the advantages and disadvantages of a deferred adjudication plea?
I have, Judge, and we've met several times, so I believe he's competent.
All right, Mr. Bell, in cause number CR 24-298, you are charged with the offense of criminal mischief, state jail felony. I see today that your plea agreement with the state would contain you pleading guilty to a Class A misdemeanor offense of criminal mischief greater than $750, less than $2,500. A Class A misdemeanor has a range of punishment of confinement in the Van Zandt County Jail not to exceed 365 days or a fine more than $4,000. In exchange for your plea, the state's recommending that the court defer a finding of guilt, not convict you of that offense, for the court to place you on 2 years community supervision, ordering you to pay restitution in the amount of $1,187 and court cost of $270 and reimbursement fees of $35. And the state, as part of the agreement, would be dismissing cause number CR 25-1, which is a burglary of a habitation. In addition, they would also be dismissing and asking the court to dismiss cause number unfiled DA number 2024-463, which is another criminal trespass. Mr. Bell, is that your understanding of the plea agreement?
Yes, sir.
Any questions about any of that?
Just the restitution.
Judge, if I might, the restitution was paid by the insurance carrier, and I've sent that proof from the body shop to the DA's office. So it shows the restitution, but it's been paid.
Okay. Any other questions about that, Mr. Bell?
No, sir.
Okay. All right, Mr. Bell, then understanding the plea agreement and the range of punishment, how do you plead to Class A misdemeanor criminal mischief?
Guilty.
Are you pleading guilty to that Class A misdemeanor crime because you are guilty of committing that crime?
Yes, sir.
And has anybody threatened you, forced you, or pressured you to plead guilty?
No.
All right, the court will accept the defendant's plea of guilt. Mr. Wells, any objection to the evidence being admitted?
No, there's no objection.
All right, that is admitted, and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Your Honor, only that state is in compliance with victim services, and victim is fully supportive of the plea agreement.
Thank you, Mr. Hartwell. Anything further from the defense?
Nothing further, Judge.
All right, court will consider the evidence. All right, the court having considered the evidence finds enough evidence to convict the defendant of the offense, the court will follow the plea agreement between the state and the defendant. The court hereby defers the finding of guilt on Class 8 misdemeanor criminal mischief greater than $750, less than $2,500. Court places Mr. Bell on 2 years community supervision, orders him to pay restitution of $1,187, court costs of $270, and reimbursement fees of $35. Court also, as part of the agreement, grants the state's motion to dismiss cause number CR 25-1, burglary of a habitation, and dismisses under section 1245 DA 2024-463 a criminal trespass offense. Mr. Bell, you hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'm going to have you come forward to be fingerprinted with Sergeant Martinez. After that, you'll meet with the probation officers.
Yes, sir. Thank you.
Mr. Wells,
Yes, Judge.
I just want to commend you on becoming a scholar of technology and the way.
Difficult.
Well, obviously it wasn't difficult for you. You got it done.
I got it so early, you couldn't find it.
I may or may not have lost a bet on whether or not this electronic plea was going to happen today for you, but
Don't bet against me, Judge.
after today, I never will. And so I want to commend you on getting that done and appreciate your service. Mr. White, are you Mr. Swallows ready?
Yes, sir.
All right, court is back on record in cause number CR 25-16, State of Texas versus Philip Wayne Swallows. When we left off, Mr. Swallows, I was asking you about whether or not you were pleading guilty to the offense because you were guilty of that. I saw some resignation on your part and that you were shaking your head in the negative. So I asked you to consult with your attorney. Mr. White, have you had a chance to discuss the procedure with Mr. Swallows, and are there any concerns about the plea going forward?
Your Honor, there were a couple things going on. One, Mr. Swallows, I guess I didn't explain this very well. He thought the court cost him $2,700 and he was not feeling very good about that. And I explained to him that the court cost were $270, not that. And then I explained to him that our situation, what he was charged with, and after that, he instructed me that he wanted to go ahead and go forward with.
All right, Mr. Swallows, you understand you're still under oath in your testimony. You understand that?
Yes, sir.
Okay. All right. And so, Mr. Swallows, I've given you an opportunity to speak with your attorney, Mr. White. Do you have any questions before we proceed with this plea agreement?
No, sir.
Okay. All right. So, Mr. Swallows, I would ask you at this time, how do you plead to the Class 8 misdemeanor offense of criminal trespass of a habitation? Guilty or not guilty?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing criminal trespass of a habitation?
Yes.
And has anyone threatened you, forced you, or pressured you to plead
No,
guilty?
sir.
Okay. Court will accept the defendant's plea of guilt. Mr. White, any objection to the evidence being admitted? All right, the evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Your Honor, only that I know the state is in compliance with victim services. I don't have a direct note as to victim support. I believe the victim is supportive. But I don't have a direct note on that, but I know we are in compliance.
All right, thank you, Mr. Harwell. Anything further from the defense?
Your Honor, just for the court, when we get done here, Mr. Swallows is gonna go over to the clerk's office, set up a payment plan, is gonna pay the 100 into the court fund today.
Okay, thank you, Mr. White. All right, court's going to review the evidence. All right, the court, having reviewed the evidence, finds enough evidence to convict the defendant of the offense. The court will follow the plea agreement today. The court hereby convicts Philip Wayne Swallows of Class A misdemeanor criminal trespass of a habitation, assesses punishment at 2 days confinement in the county jail, awards Mr. Swallows 2 days credit towards his sentence. The court also orders him to pay a $2,500 fine, court cost of $270 and reimbursement fees of $35. Mr. Swallows, you're hereby remanded to the custody of to the custody of the sheriff's office so they can carry out the terms and conditions of the sentence. I'm gonna have you come forward. You're gonna be fingerprinted with Sergeant Martinez, and then you can step across the hall and make your payment arrangements with the clerk.
Your Honor, that's all I have.
Thank you, Mr. White. See you this afternoon at all? No? Have a good day. This is cause number CR 25-176, State of Texas versus David J. Brooks.
I need to bring this up here with me,
What is that?
for the pretrial.
No, that'll go to your pretrial release officer. All right, Mr. Brooks, today you're set for arraignment on a second-degree felony offense of possession of a controlled substance. Penalty group 1, greater than 4 grams, less than 200 grams. That does carry a range of punishment should you be convicted and sentenced to not less than 2 years in prison, up to a maximum of 20 years in prison, and a fine not to exceed $10,000. I see that you have requested a court-appointed attorney. Based on the information that you have provided, the court finds that you are not indigent at this time, not entitled to a court-appointed attorney. So what I can do, Mr. Brooks, is I can reset your case for about 30 days to give you time to get the funds up to go hire an attorney to represent you. Is that what you want to do?
Yes, I actually have a question though. So, I mean, I don't really know how to explain this. Like, I got pulled
Well,
over.
hang on. Today is not the day to come in
Okay.
and talk about the legalities of your case, because what you say in here could be used against you in your trial later. There's a prosecutor here, so you don't want to
See,
stay.
and that's what I'm trying to avoid. Like, I don't want to go to trial.
Listen, I know, but this is not how it works, okay? You don't come in here and say, hey, judge, this is what happens. This is what I want to do. This is a felony offense. You're looking at minimum 2 up to maximum 20 in prison.
Right.
So right now, all we're doing today on arraignment is we were to fix your identity and make sure you understand what you're charged with. It's a very serious offense. It's not a traffic ticket. Okay. So today's not the day to come in and tell me about what happened and for me to make a decision. Okay.
Yes, sir.
Today's about, are you going to represent, you've requested a court appointed attorney. You have assets and money that prevent you from being entitled to court appointed attorney. So I can do one of two things. I can reset your case and give you time to hire an attorney who can then discuss your case with the prosecutor and see if you can reach some kind of agreement or dismissal or whatever. But that attorney has to do that. Or if you don't want an attorney, you can represent yourself if you meet certain criteria.
Okay.
Okay.
Yes, sir.
So what do you want to do? Do you want me to reset your case, or do you want to represent yourself on a serious felony?
I would like a reset so I could try to find a lawyer.
Okay. So what I'll do is today's the 26th. I'm going to reset you to Tuesday, September 30th. And I'm going to give you some tips when you go and try to find an attorney. If the first attorney you can't afford, keep on calling. Don't make assumptions that all attorneys are going to charge the same amount. Keep on calling until you can find an attorney that you can afford, that you feel comfortable with, and that practices criminal law. Don't go call a probate attorney and spend time trying to get a hold of someone to represent you on a criminal matter.
Right.
Okay. Also make sure that you're speaking with an attorney that's willing to practice here in Van Zandt County. So don't go call someone in Midland.
So do y'all have a list that I could get before I leave for that around
No,
here?
you can get that online. You can Google attorneys in Van Zandt County. You can go to the State Bar of Texas. But we don't have a list because we can't make referrals to private attorneys.
Yes, sir.
Okay. So I'm gonna have you sign a notice of appearance, and it's saying that you're gonna come back on September 30th. And let me see, let me write on it. Take this form with you when you speak with attorneys so they know about when your next court date is and what you're charged with, okay? All right, so sign that and we're gonna give you a copy of it, okay?
Yes, sir.
And Mr. Brooks, you're gonna meet with Mr. West. He is the court's pretrial release officer. He's behind you there. He's gonna go over some paperwork with you, okay?
Yes, sir.
After that, you're free to go.
Thank you.
Send it in. Well, they can show it. The Mr. Juarez. This is cause number CR 23-183, State of Texas versus Max Alexander Juarez. Mr. Juarez, you're here today on the state's motion to adjudicate. I see that you've requested a court-appointed attorney.
No, sir. I was just asking if it was really needed, because right now I'm going through some financial issues, but I mean, if I have to hire one, I will. That's what I was trying to get at, because
The state has filed its motion to adjudicate, so all I can do now is tell you that they're asking for a prosecution of you, so apparently it is needed. Okay, so you want me to reset you and give you time to hire an attorney?
I mean, you could just give me the next day, and by that time I'll have one ready.
All right, court will reset you for, we're gonna do October 2nd. So Mr. Juarez, I'll have you come back on October 2nd. And I need you to have your attorney hired before that time, okay?
So I just keep doing what I've been doing with the payments and everything.
Yeah, you're still on probation,
Yes, sir.
so you need to continue to comply with your conditions of probation. But the state has filed a motion to adjudicate you, so okay, so that issue will need to be resolved. Yes.
And that's all that's needed.
Yes, you're free to go, and just make sure you're still checking in with your probation officer.
Yes, sir.
Okay. Yeah. Oh, he still has plenty. Chris, where's your partner in crimes? All right, who are you ready on?
Mark Martinez.
Mr. Martinez? This is cause numbers CR 25-97, CR 25-122, State versus Mark Anthony Martinez. Court finding that Mr. Martinez has requested court-appointed counsel. Court finds him to be indigent at this time. Court has appointed the Honorable Richard Schmidt as counsel, and we are set for arraignment today. Mr. Schmidt, have you had a chance to go over the indictments with Mr. Martinez?
Yes, sir, I have. His name is correctly laid out. We understand the charges. We'll waive formal reading, enter a plea of not guilty to both those as for pretrial setting.
All right, the court enters Mr. Martinez's plea of not guilty into the record in each cause, finds that he has waived the formal requirements of arraignment. Court sets Mr. Martinez for pretrial hearing.
Can I get a little extra time?
Sure. How about you want to do October 14th?
Yes, sir.
All right, court sets Mr. Martinez for pretrial October 14th. 9 a.m.
So, this is your recent notes. You'll get a copy of this, so you'll know something else. Just got a point today. Make sure you finish filling out that stuff for Mr. West.
I did already.
You got it to that?
No, I waited. He's hard to find.
Yeah. All right.
If you know if Mr. Martinez has conditions of pretrial release.
Yes, sir. He was meeting with Mr. West this morning.
He was?
Finished filling out all his paperwork.
Okay,
Get it back to him.
he's free to go.
Here you go.
Thank you, sir.
Christopher Blevins.
Mr. Blevins. This is cause number CR 25-154, State of Texas versus Christopher Wayne Blevins, set for arraignment today. Go ahead, Mr. Schmidt.
We have received a copy of the indictment, judge, name spelled correctly, understand the charges, waive reading, enter a plea of not guilty. Ask for that October 14th pretrial date.
All right, the court finds that Mr. Blevins, having waived the formal requirements of arraignment, the court enters his plea of not guilty into the record and sets Mr. Blevins for pretrial hearing October 14th at 9 a.m. Mr. Blevins, have you met with Mr. West this morning and signed your conditions of pretrial release?
Yes, I'm in the middle of filling it out.
All right, once he tells you that he's done with you, then you're free to go.
Okay.
Okay. All right.
I'm sorry.
Who would you like next?
Judge, if I could have about 5 minutes, I'm gonna meet with Mr. Blevins.
Yes, sir.
Mr.
Ready, Mr. Schmidt?
Yes, sir. This is Nathaniel Brooks.
All right, this is cause number CR 25-165, State of Texas versus Nathaniel Junior Brooks. We're set for arraignment today. The court finds that Mr. Brooks, having requested court-appointed counsel, finds him to be indigent. Court has appointed Uncle Richard Schmidt as counsel, and he is set for arraignment today. Go ahead, Mr. Schmidt.
That's correct, Judge. Mr. Brooks and I have gone over the indictment together. His name is correct. He stands the charges. We'll waive reading and enter a plea of not guilty. Ask for that October 14th pretrial date.
All right, the court enters Mr. Brooks' plea of not guilty into the record, finds that he has waived the formal requirements of arraignment. Court sets him for pretrial hearing October 14th at 9 a.m.
So, you need to finish filling this out, give it back to Mr. West.
Well, I think we haven't finished.
All right, is that your copy?
Yeah.
We're good. to go. Okay.
All right, so there's two issues. One issue is, Mr. Brooks, when you were arrested, I presume you were arrested outside of Van Zandt County, is that correct?
Yes, sir.
Okay, because of that, the Justice Center here in Van Zandt County does not have a complete copy of your fingerprints to submit to the state that they're required to do. Therefore, I'm gonna have you go to the Van Zandt County Justice Center so that they can take your fingerprint so that they can comply with the law and report it. You're
Okay,
not gonna be booked in or anything of that nature. You're just
that's
gonna be
fine.
your fingerprints will be taken. So I'm going to give you what's called a TRN processing order. You'll take this along with your photo ID to the Justice Center, tell them you're checking in that you need to comply with this order. They'll get you back as fast as they can and they'll process that. Okay.
Okay, no problem.
The other issue is court starts at 9 o'clock.
I was outside with the pre-trial guy. I didn't know
You
where
were
to go.
late.
I didn't know what to do, so I was filling out the paperwork, trying to.
Were you there in the hallway at 9 o'clock? Was it
Yes,
for this?
yes, sir. Yes, sir. Yeah, I met with the Mr. West with the striped shirt. As soon as I came through the door, he was right there. Gave me the paper. I started filling it out over here. I've been sitting right here. I didn't know them coming. This is my first time coming to this county.
Okay. So you saw me walk by you when I started court?
I don't remember.
I don't think you were here on time. I think you were late. So I'm just telling you, court starts at 9 o'clock and you need to be here. Okay?
Yes, sir.
All right. All right, we'll see you back at 14. Make sure you see Mr. West before you leave.
Thank you.
This is your driver's license or picture ID.
Yes, sir.
So the jail is right next to mine. Unless you take this document with you, go up into the window and say, Judge ordered me to book in. That's to take you to the back. Just take your fingerprints. Kick you out the door.
Okay.
Cool?
Okay.
Don't skip it though. 'Cause-
Okay. I'm gonna go now.
All right, sure.
Thank you.
You're welcome.
Have a great day.
Anything else, Mr. Schmidt?
I don't believe so.
Let's call your two in custody cases. Cause number CR 24-128, State of Texas versus Wyatt Lane Berkwin. If Mr. Berkwin is still in custody in the halfway house pursuant to safety, court will reset Mr. Berkwin then for status October 14th at 9 a.m. Court calls cause number CR 24-164, State of Texas versus Shunta Rena Foster. Ms. Foster set for arraignment today, is verified in custody in Gregg County. Court will reset Ms. Foster then for status of custody and competency restoration October 14th. 9 a.m. All right, is that all you have, Mr. Schmidt?
I think so, Judge. I think Ms. Hartwell is, we wanted to speak to the court, but I'll sit out. Wait.
Okay. All right, you're Miss Harrison?
First.
Harrison? All right, this is cause number CR 25-47, State of Texas versus Chrissy Lee Kaiser. Counsel, will you approach? All right, that concludes the, well, let me place on the record for Ms. Kaiser. The court is resetting Ms. Kaiser to September 30th at 9 a.m. Court will sign the e-file order. Ms. Kaiser has checked in and signed her conditions of pretrial release. All right, that concludes our morning docket. We will stand in recess till 1:30. Yes, ma'am, please.